We have a new motion from the defense, and this will be a two-part recording. It's a very long one, so get some coffee and settle in. State of Indiana, County of Carroll. State of Indiana versus Richard Allen. Accused response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. Comes now accused Richard Allen by and through counsel and files his response to this court's May 31st, 2024 order of judgment of the court and notice of conflict in support of said motion. Mr. Allen states the following. Introduction. 1. On May 31st, 2024, this court issued its order of judgment of the court concerning the defense's request to have Judge Gull disqualified. 2. Contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed which has caused Judge Gull to become a witness. 3. The defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place, particularly hearings related to the defense's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that need litigated. Also, the defense's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligation to recuse herself from the case, should she believe that bias or the appearance of bias exists. Side note. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Abney v. State, 79NE 3rd 942-951, Indiana Court Appellate, 2017. Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. 4. In his motion to disqualify, Mr. Allen noted that, according to a June 14, 2023 report filed by Carroll County Sheriff's Office, herein referred to as CCSO, Judge Gull advised the CCSO that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refused to transport him to the June 15, 2023 hearing on Mr. Allen's emergency motion to modify safekeeping order. The defense further alleged in its motion to disqualify that because of Judge Gull's actions, the defense was without a key witness for the hearing. 5. It was anticipated that at the June 15, 2023 hearing, Mr. Baston would testify as to the harsh, abusive, and unconditional treatment of Richard Allen at Westville Correctional Facility. Number 6, the failure of the CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. However, number 7, in her May 31st, 2024 order, Judge Gull claims that she never advised the CCSO to ignore the subpoena and leave Baston behind. 8. Judge Gull's claim contradicts the CCSO report that the court received on June 20th, 2023. Number 9. The June 14th, 2023 report, which was ordered by the court, stated the following. June 14th, 2023. I, Special Deputy Wysocki Bryan, while on duty, was conducting transport for Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston, Robert, dock number 209210, segregation unit to conduct the pickup. After waiting, a correctional officer approached and told me Baston is refusing to come out of his cell and told the corrections officer, F you can't make me go. The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo. I called Carroll County Jail Commander Lori Sestarsik, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Lesenby and contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6/15/23. I then spoke with Warden Gallipo and asked if he would provide me with a letter stating that Baston refused to come out of his cell, that he did not want to go. Warden Gallipo agreed he would. He later advised he would bring me the letter on 6/15/23 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. 10. The report was approved by Tobe Lesenby, who is a key witness in this case. 11. Just opposed to the CCSO report is Judge Gull's May 31st, 2023 order, in which she stated the decision by the deputy to leave without the witness was his and was not directed by the court. 12. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. Judge Gull has possessed this report since June 20th, 2023. 14. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. 15. At the very moment of learning that CCSO filed a report with fabricated facts concerning Judge Gull, she could have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. 16. Further, upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence Mr. Allen was able to present, Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. 17. Additionally, as this court is aware, Mr. Allen has filed 4 Frank's motions indicating that law enforcement has acted intentionally or in bad faith. 18. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18, 2024, with the court denying said motion on April 2, 2024. 19. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to provide or prove that law enforcement acted in bad faith. Pimentel v. State 181 NE 3D 474481, Indiana Court Appellate 2022. Number 20. At the March 18, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement was acted in bad faith over the course of this case. At that time, this court was aware that law enforcement had fabricated facts contained in the June 14, 2023 report, thereby acting in bad faith. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. 21. Even this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss. The fact is, the defense was not able to include that information on the record for the Court of Appeals, should it be necessary. 22. Additionally, had Judge Gull alerted Mr. Allen's attorneys of Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Frank's motions and motion to dismiss in order to provide additional evidence of intentionality and bad faith on the part of CCSO. 23. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defense from investigating this fabricated story, including through depositions. 24. Judge Gull should have alerted Mr. Allen's attorneys of CCSO's fabricated facts written in their police report well before March 18, 2024, motion to dismiss, and her failure to do so provides a rational inference of bias. Judge Gull is now a witness in this matter as to Tobe Lesenby's credibility. 25. Given that Judge Gull is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Baston at Westfield, despite the contrary assertions in the CCSO report, she has become a witness to Tobe Lesenby's truthfulness and to the fact that the information contained in CCSO's report is false. 26. The credibility of a witness is also an issue for the jury. Stanley v. State, 273, Indiana 1318 401, NE 2D 689 692, 1980. 27. If Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the CCSO and or the bad faith of the CCSO in that it 1. Intentionally ignored a valid defense subpoena for a defense witness, and then 2. Fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. 28. At future hearings and at trial, the defense should have the ability to cross-examine Tobe Lesenby on these contradictory stories with questions similar to the following. Attorney: Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville. But your office ignored a valid subpoena to bring the witness to a hearing. Isn't that right? Attorney: You did not want the judge to hear the testimony of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to the Cass County Jail closer to both his family and attorneys and away from the abuse. Attorney: You wanted Richard Allen to remain in the Westfield prison so that he would continue to be housed far from his attorneys and family while emotionally vulnerable to the abuse he was suffering at Westville. Attorney: Worse yet, you then lied in report claiming that Judge Gull advised you that it was okay to leave Baston behind. You lied about that in your report. Attorney: Judge Gull never told you that it was okay to ignore a valid defense subpoena, did she? Attorney: I'm handing you Exhibit 85, which is the June 14, 2023 report from CCSA, in which you claim that Gull gave the directive allowing you to ignore the subpoena, etc. 29. Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motions to dismiss as well as the 4 Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statements contained in the CCSO's June 14, 2024 report. Judge Gull's testimony is especially vital concerning the defense motions to modify the safekeeping order, as well as their Franks motion and motions to dismiss. 30. Calling Judge Gull to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is the subject of this report, Robert Baston, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. The defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed CCSO to ignore a valid subpoena and also never advised CCSO to leave Robert Baston behind if he, Baston, did not want to attend the June 15, 2024 hearing. 32. Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. Judge Gull's failure to admonish the CCSO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. 33. Despite having the CCSO report since June 20th, 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such flagrant falsehood and which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. 34. Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for state's witness to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. 35. In its May 31, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. 36. On March 7, 2024, Attorney Rosie alerted Judge Gull about his grave concerns surrounding McClellan receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 2024 emailed response, Judge Gull wrote to the defense counsel, "I would encourage you to educate your staff on how to properly file pleadings." 37. Attached is a printout from the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. It's Exhibit A. 38. It should be noted that upon receiving this February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper procedures in processing an ex parte pleading. 39. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows that the only service contacts listed on this ex parte filing were Brad Rosie and Andrew Baldwin, not Nicholas McClellan, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. In her May 31, 2024 order, Judge Gull seems to believe that parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the DocsPop platform, which is the platform defense staff utilized when they correctly filed the February 26, 2024 ex parte document in this case. Over the course of this case, defense staff has used both Odyssey and DocsPop platforms when e-filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defense details how court staff should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. 40. There is nothing else that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using the Odyssey or DocsPop platforms. 41. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how it processed the document into the system, causing Prosecutor McClellan to have access to the ex parte document. 42. In her May 31, 2024 order, Judge Gull detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for 3 reasons. 1. The defense was not errantly filing ex parte documents. 2. The tutorial Judge Gull sent to the defense had nothing to do with assisting practice lawyers on how to file ex parte documents. And 3. The defense continued to file ex parte documents in the same exact manner it had been filing before Judge Gull ever sent the tutorial to the defense, and there were no issues. 43. The tutorial Judge Gull emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is tutorial for court staff. Please find attached a printout of the tutorial Judge Gull sent to the defense marked as Exhibit B, which also includes the cheat sheet referenced in the letter from Office of Court Services. Even though on its face, this tutorial clearly appears directed to assist court staff in understanding how to process, accept ex parte filings, the defense staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It does not. When defense staff clicked on the link detailed in Step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed in order as helpful to the defense was actually meant for the court staff. Judge Gull has failed to admonish Prosecutor McClellan for improperly reading ex parte pleadings while continuing to denigrate defense counsel. 45. The pleadings, errantly made accessible to Prosecutor McClellan, were clearly marked ex parte. 46. The defense became aware that Prosecutor McClellan read the ex parte documents based on March 6, 2024 prosecution filing, in which the prosecution directly quoted from the defense's ex parte filing from February 26, 2024. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. 47. After reading Prosecutor McClellan's March 6, 2024 filing and realizing that McClellan had reviewed a defense ex parte document, Attorney Rosie sent an email to Judge Gull, and one of Judge Gull's staff members, as well as Nick McClellan, find attached copy of said email marked as Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. 48. Then on March 7, 2024, Prosecutor McClellan filed a pleading in which he, McClellan, finally admitted that he also had access to 3 other ex parte filings. 49. Despite the clear marking of ex parte on the documents, Prosecutor McClellan chose to read those ex parte documents rather than promptly deleting them and alerting the defense of the misdirecting filing as required under Indiana Rule of Profession Conduct IRPC 4.4b. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. 4. After reviewing the record, the defense believes the Prosecutor McClellan actually reviewed only 2 ex parte filings, as 2 of the filings that he referenced in the pleading he identified as ex parte are not actually ex parte filings. 50. Prosecutor McClellan never contacted defense counsel after receiving the ex parte documents as required under IRPC 4.4b. The defense only learned of this violation upon reviewing McClellan's March 6, 2024 pleading, in which McClellan audaciously quoted directly from the ex parte document, thereby making said quote available for the public. 51. The act of McClellan reading from defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. 52. This court has failed to reprimand the prosecution for reading ex parte documents or to even address the issue in any way whatsoever. Nor has Judge Gull filed a pleading in which she, Judge Gull, publicly proclaimed that she is referring Nick McClellan to the Office of Judicial and Attorney Regulation, Executive Director Adrian Meering, for that office to enforce the rules to determine counsel's ethical misconduct. 53. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel sent out to media sources when no gag order was in place and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegations of McClellan reviewing ex parte documents and violating IRPC 4.4b, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than the defense counsel, and this provides a rational inference of bias. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rosie. 54. In her May 31st, 2024 order denying the defense's request for disqualification, this court maintained that it has no bias against defense counsel. Side note. This quote is taken from Judge Gull's April 30th, 2024 order of judgment of the court concerning the prosecution's request that the defense counsel be found in contempt. 55. On January 22nd, 2024, this court denied Baldwin's and Rosie's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks request for over 4 months. Yet within 4 days of their re-entering their appearance on the case, Judge Gull denied the request without hearing. 56. However, after Baldwin and Rosie were taken off the case in October 2023, Judge Gull informed her newly hand-picked public defenders that they would review prior counsel's pleadings and either adopt those pleadings or make their own. In that November 14, 2023 CCS entry, it was memorialized that Judge Gull informed the new public defenders, Scrimmin and Librato, that if defendants' new counsel informed the court they intend to pursue the Franks motion, the court will schedule a hearing. 57. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rosie, and that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. 58. This disparate treatment of attorneys Baldwin and Rosie compared to this court's treatment of the prosecution and even the replacement public defenders provides a rational inference of bias against defense counsel Baldwin and Rosie and therefore against Richard Allen. In its order, this court claimed that it is irrational and unreasonable for the defense to assert that as lawyers of 70 years combined experience, they've never had a judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of Jury Rule 4. 59. This court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their averments that the courts around the state of Indiana never set a rigid day for the trial to end. Implicitly, the court is also averring that defense counsel are lying about their experiences in other courts according to the state of Indiana. Furthermore, this court maligns defense counsel concerning its knowledge of the jury rules, when in it is the court that is incorrect in the assessment of the jury rules. 60. At May 7, 2024 pretrial hearing, the court stated, "Well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to jurors with the dates." Transcript May 7, 2024, hearing P12, line 13, emphasis added. 61. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length of trial dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that Not later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail each person whose name is drawn as a juror qualifications form and notice of the period during which any service may be performed. 62. Jury Rule 4 is primarily referring to the time span of term during which citizens need to be on alert that they could be summoned in for jury duty. For example, when they are on call for possible jury duty. The prospective juror needs to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror at that later date. 63. Jury Rule 4 further states that when summoning a prospective juror in for the jury duty, that the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, for example, cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the American with Disabilities Act. 64. Note that Jury 4 rule does not require the court to provide dates of the actual trial or the length of the actual trial, nor does Jury 4 require the prospective juror to be advised of the beginning date or end date of the trial. 65. Jury Rule 9, term of jury service states, a person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of length of the trial or the manner in which the trial is deposed. 66. Once summoned in and selected as juror, Juror Rule 9 is the jury rules that comes the closest to referring to the length of the actual trial. 67. Note that Jury Rule 9 places no limit to the length of actual trial once a juror is selected, nor does Jury Rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. 68. In spite of Judge Gull's proclamation at the May 7, 2024 hearing, Indiana jury rules did not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends the citizens pursuant to Jury Rule 4. 69. Judge Gull's errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. 70. Judge Gull's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. Side note, in Marion County, for example, prospective jurors arrive and gather in a large room not knowing which court or what trial they may be called upon to serve, as often multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve on any one of those trials. 71. Additionally, at the May 7, 2024 hearing, Judge Gull cited several cases over which she has presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. 72. This is the case of State of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 plus miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. These situations arise in trials, especially in a factually complex trial with approximately 185 witnesses identified by the parties. 73. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than fact witnesses. 74. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. 75. Additionally, it is shocking and disconcerting that the court refuses to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to represent or present his defense. 76. Under the court's prior order, the trial was to last from May 13, 2024 through May 31, 2024, thereby allowing approximately 13 days for opening statements, testimony, evidence, rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surrebuttal evidence, arguing or final instructions, and closing arguments. 77. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to compulsory process of witness, and his 14th Amendment due process right to present a defense. 78. In the context of its request for Judge Gull to disqualify herself, this court maligning of defense counsel as irrational and unreasonable, when in fact it was this court that was wrong in its understanding of jury rules and also wrong in its claim that courts statewide provide a hard end date to a trial, offers a rational inference of bias against the defense. Judge Gull's May 31, 2024 explanation of her denial of defense motions without a hearing provides a rational inference of bias. 79. In its May 31, 2024 order, when explaining why the court denied several defense motions without hearing, the court stated, "If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing." 80. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? 81. Judge Gull's claim that the defense evidence is inadmissible before conducting a hearing and before listening to the defense's contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. 82. This court's denial of defense motions without a hearing based upon the reasons this court cites in its May 31, 2024 order establishing that this court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that this court is prejudging evidence. This court's denying the defense's request contained in its pleadings without a hearing, based upon her prejudging evidence, provides a rational inference of bias. 83. In the future, if this court denies defense motion based upon the court's belief that the defense pleading is not supported by the law or admissible evidence, the defense requests the court to identify the evidence cited in the defense pleading that the court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible. Also, instead of simply stating denied without hearing, the defense will request the court to explain why the pleading is not supported by the law. Even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. 84. In her May 31, 2024 order, Judge Gull expressed that she does not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identified and some are less perceptible. 85. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions she makes towards the defense versus the prosecution. 86. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. 87. At the June 15, 2023 hearing, Prosecutor McClellan requested a recess and the following transpired. McClellan: Judge, I have 2 witnesses. Could I ask the court for a short recess just so I can use the restroom? Judge Gull: Would counsel approach? Sidebar conference conducted. Judge Gull: I just want to know what kind, where we're at. You got 2 witnesses? McClellan: Tony Liggett and the Westville warden. Judge Gull: Okay, do you want a break for lunch? Rosie: I don't, but I'm... Judge Gull: Okay. McClellan: So I don't care, I can inaudible. Judge Gull: Yeah, we can take a quick break. How long? I don't mean to be pain, but... Judge Gull: No, that's all right. How long do you think you'll be? McClellan: Downstairs and right back up.